Hi, my name is Tina Huang. I'm a Senior Associate at QueenCityLaw, and today I will be talking to you about common employment issues that every business should know about. This information is true and correct to September 2022 and should not be taken as legal advice. So, number one, I just have 5 tips for you today. Number one is that a contract needs to be in place. Now, there's a misnomer that if somebody is on a trial period, they don't need to sign a contract until the trial period is over. But news for you, everyone needs to sign a contract before they begin any work, and that includes volunteers as well. So, a contract needs to be in place, otherwise you could be subject to a big hefty fine. A contract needs to have the name of the parties, the position, whether they're full-time, part-time, casual, what they're getting paid, what the hours are, where they're required to work, information on what happens if the employee wants to raise a personal grievance or dispute, and how to resolve any of those issues. We strongly recommend that you get legal advice before you sign this document. Number 2 is that a trial period is different from a probation period. A trial period is what most employers want, but if you have more than 20 staff, you are not allowed to have a trial period. So basically, a trial period is your get out of jail free card. If you want to test an employee and put them on a trial period to see if they're right for you, and you find that they're not, you can dismiss them and they cannot bring a personal grievance claim against you. However, a probation period obliges an employer to follow good faith due process obligations under the Employment Relations Act. That means that if you want to fire somebody, you need to go through the correct processes and you can't just dismiss them on the spot, and they do have rights to bring a personal grievance claim if that process is not followed. Number 3, health and safety at work. This is an important one because laws have changed and now you can be personally liable. So under the Health and Safety at Work Act, most employers now need to protect the safety of their employees, and there's now a new definition of a PCBU, a new terminology that's been introduced. This is a person of a business conducting or undertaking something in the business which makes them liable. So every workplace now needs to have a health and safety policy, and if you are a construction business, you need to have one for each individual site. It needs to protect your workers to make sure that they are protected at all times, and health and safety is paramount. This is important because WorkSafe are now bringing more charges against employers and conducting investigations if you are not compliant with this, so make sure that you are compliant. Number 4, personal grievance claims. Now, these are the words that you never want to hear as an employer, so be careful. Understand your obligations of due process and good faith. These are actually really difficult to fulfill, so really seek legal advice if you have any issues. Migrant exploitation is a word that Employment Relations Authority and courts do not want to hear, and that is another issue they will tackle down on, so be careful that you don't get caught into that kind of mess. Now, a personal grievance claim means that employees normally have 90 days to raise this with you, but they can get an extension from the Employment Relations Authority, so be careful about this. Also, it is a very stressful process for employers and employees alike, so really try to avoid this where you can. And I have acted for both employers and employees in such matters, and I haven't really had one where somebody wasn't crying, so it's very painful. I've also had an employer feel so justified that they have fired their employee because they obviously stole money from them, but because they didn't follow the due process, they in turn had to actually pay money to that employee who stole money from them, and they thought that it was so unfair, but because they didn't follow the due process, that's what they ended up doing. So please be careful that you don't get caught up in such a mess. Last one, an employee is different from a contractor. An employee and a contractor aren't what they are just because you name them like that. So terminologies don't matter. Case law looks far beyond that. So you can call somebody a contractor, make them pay for their own tax, but if what they're doing seems and sounds like an employee, then the Employment Relations Authority and court are likely to deem them as employees. This brings them a whole line of protection and rights, so then you'll be liable for giving them annual leave, sick leave, bereavement leave entitlements, and they will of course have rights to bring a personal grievance claim. So be careful that you understand the difference between an employee and a contractor, because just because you call somebody a contractor and just because they sign a document saying that, it doesn't mean that they are. So you really need to understand the complexities behind this, because the potential consequences could be humongous. So those are just 5 simple things that every employer needs to know about in terms of employment law in New Zealand. It is quite complex, so make sure you get the right advice before you sign any documents or bring anybody on board. We're here to help you navigate this difficult process and make it simple for you. So please feel free to contact us if you have any queries. Thank you for your time.